I'm going to introduce you to some concepts, right? So that you can learn more and be better prepared when you meet with your lawyer. And maybe that's you're meeting with somebody in our firm because we're happy to take on new clients. Maybe you're meeting with your tax advisor, your financial advisor. These are some things that I think you need to know if you're married and you have income or wealth. I mean, pretty much everyone does, right? So I'm Jim Cunningham. I'm a partner at Cunningham Legal. I have over 25 years experience. We have offices throughout the state of California, and I'm a certified specialist in estate planning, trust, and probate law. I'm also a real estate broker, securities and insurance licensed, and a pilot single engine land. We have 10 lawyers in our firm now. Here's myself and my two partners, Rochelle Lee Warner and Tasha John, and just a great group of people here. Really, we get to do this. It's not like we have to do it. So it's a real honor and it's a privilege to help each of our clients on things that are really so personal. When you talk about trust and estate, you talk about peace of mind. This is very personal. And when you get into marriage and widows and widowers, it really kind of takes it to the next level. So disclaimer, I'm going to be talking about a whole bunch of stuff. Okay. This is not legal advice. This is information only. And it's to introduce many of you. And if you're watching this, you may think, I know nothing about this. I'm married. What should I be paying attention to? What are estate planning and tax strategies for spouses? Now, these are people who are married. What happens when a spouse dies? Does it all go to the surviving spouse? Does it go outright? Meaning, here's your check. Does it stay in trust? What about probate? Do you avoid probate just because you're married? Spoiler alert, no. Many people who are married, when that spouse dies, that surviving spouse ends up in probate court. And who takes care of the kids? That would be designating a guardian. If you have minor children or you have an adult child with special needs, and maybe you're the court-appointed conservator for that child, you need a game plan. Because if you leave this earth and you leave people who are dependent on you behind, somebody's going to take care of them. There typically is court involvement. There is a court action. It's the probate court. And for good reason, because you want these people that you care about who really can't look out for themselves. You want them protected. You have the power to let the court know who you want in that role. And that's a really important part, certainly if you have minor child or, again, adult children with special needs. And then what about incapacity? Just because you're married doesn't mean that your spouse has access to your medical records, right? That's the medical privacy, the HIPAA laws that we have now. So you need to plan around that. So if your spouse becomes incapacitated, meaning he or she can't make decisions for himself or herself, somebody has to do that. And typically that's done through the Advanced Healthcare Directive. Now, we cover that on a lot of other webinars, and I would encourage you to check out our YouTube page. We've covered this at length, and to explore more on that, check out those videos. And who makes financial decisions? So there's like who decides where you live and your medical decisions and who you associate with. And then there's who's in charge of your finances. And we're talking about maybe your successor trustee on your living trust. And again, we talk about that in other webinars. But these are really important questions about who's in charge, right? And then you have trust assets, and you have your IRAs and your 401ks and your life insurance and your annuities. Those typically are not handled by your trustee. So those are typically outside of this trust bucket that we talk about. So you have this bucket, the trustee is holding onto the handle. You put your house, your stocks, your bonds, your mutual funds into this trust bucket, but your life insurance, your 401ks, and your annuities are kind of out there a little bit orphaned in the sense that they're not covered by the trust. So many people do a durable power of attorney for property management and personal affairs to handle those. But again, this is part of a comprehensive plan. We do have a bonus for you. We have a estate plan diagnostic review. We're going to put it in the notes here, and there's a link to it. If you're watching this on YouTube, there's going to be a link in the notes. So you can just go to the notes section on the YouTube, the video that you're watching, and click that, and it'll take you to a downloadable format where you can take a kind of a 3-page test. Like, do I really need an update? What's going on? Have these things changed in my life? So we really encourage you to take a look at that. Very important, married people in California, we have to draw a distinction between community versus separate property. So those are the two big classes of property. And as we go through the materials, you're going to see it makes a really big difference whether an asset is community property or separate property. We are not talking about divorce, right? So typically there is a division of community property at divorce. What we're talking about is how is this property treated for tax purposes and how is it treated for inheritance purposes? So not the divorce context, but as you can see on the map here, we've got a lot of the states most of the states that used to be part of Mexico, plus Louisiana, Wisconsin, Idaho, and Washington. Those are all community property states. So if you don't live in one of those states, if you live in a state that's not identified here on the map, then you are not in a community property state, and you have something called marital property, which is a whole other kind of topic. But what we're talking about here is for the people who are in community property states. So if you happen to, I will just say, it is very good if you're married and you have appreciated assets to die in a community property state. Okay, and you'll see why. And if you do not live in a community property state, if you live in New York and you have a lot of depreciated assets, moving to California can be a tremendous tax benefit. Believe it or not, many people do move to California, or they do move to another community property state to take advantage of this. So something to understand is all community property gets an adjusted cost basis. Now I'm speaking specifically about California. The rules in Texas are different. If you come from a separate property state to Texas, which is a community property state, they are different. And this is really important. Don't look at this as legal advice. This is information. I'm telling you about California. I'm not talking about other community property states, specifically California. All property acquired during marriage in the state of California is community property, meaning it's 50-50. Really, it's 100-100. And the way community property works is that each spouse owns the whole, right? They have sort of this undivided half interest, but each spouse owns the whole, except property. So all property is community property, except property acquired by gift or inheritance. Now, this is really important because your earnings are community property under law. Now, this is, if you've made an agreement otherwise, if you've done a prenuptial agreement or a postnuptial agreement, then that's a little bit different. But I'm just saying, if you have no agreement in place, now France does it differently. They have a 3-tiered system. It's all, everything you bring to the marriage is community property, and everything going forward is community property, or what you bring to the marriage is separate, and anything future is community, or the third box is everything separate. So California, very specific, and this is state by state. There's no federal rules on this per se. These are all determined by state. France obviously is a unified system, and they kind of do it the French way, which is not the American way. So when a spouse dies, something very important to understand, all community property gets an adjusted cost basis. Now that means it's either stepped up or stepped down. And let me give you an example. If I buy a share of stock for $1 and it goes up to $3 and it's community property, and my wife inherits that, right? She gets that community property, that gets a full adjusted cost basis, right? And she can sell that stock for $3 and not pay capital gains tax. The same is true if we buy a piece of maybe a commercial property and we depreciate that property down to pretty much zero. I die, she has that property. She can then sell that property for, the value it was as of the date of death, assuming she doesn't take further depreciation, and she can sell that property free of capital gains tax. So this is a very, very powerful tool. So if you're watching this and you say, wow, I've got the properties and these are really depreciated. My spouse and I, we've had these properties for many decades and we're really not getting any benefit, and we really don't want to pay capital gains tax when we sell. You might think about waiting until somebody dies. Okay. And I'm not saying wait, I'm not giving you advice, but I'm saying think about that, because that, if it is community property and it's structured correctly, right, that's a whole nother puzzle. But there are methods where when one spouse dies, you can sell property free of capital gains tax. Now, this is not automatic, and this is very important to understand. You typically appraise assets. You have them valued. So you have an appraisal on property. You might have a business valued, depending on the context. But my point here is you do need to have these valued. We do recommend that whenever a spouse dies, that surviving spouse consider filing a Portability 706. Now, this is a death tax return. The technical term's a federal estate tax return, but people really don't understand what that is. That's why I call it a death tax return, because it's the return you file when somebody dies. So this is a return that's due, and you can, as a spouse, as the surviving spouse, you can inherit your deceased spouse's ability to leave $12,920,000 tax-free and add that to your $12,920,000 coupon. So you can leave what's almost $26 million tax-free. Now you might say, Jim, well, that's fine for people who have 26 million, but we only have 3 million. Why do I need to bother with portability? Guess what? We don't know what's going to happen in the future. Death taxes could go up, right? meaning they can drop the amount that you can leave tax-free, because it used to be, when I started practicing law, it was $600,000, pretty measly, pretty stingy, meaning you could leave $600,000 tax-free. And that slowly went up over time, but it could go back down to 600,000. I have no idea. You know, the government spent so much money. People in the know, quite frankly, believe that taxes are going up. Now, I'm not saying that as a political statement. I'm not behind it. I'm not against it. I'm just saying a lot of people just look at what's going on and say taxes are going to have to go up because the government has put so much money during COVID in the economy. It's got to get it out to fight inflation. So that's what a lot of people are saying. So the two most common mistakes, I would say, so circling back on the portability, the reason you would want to file portability is the future is uncertain. You want to grab that $12,920,000 death tax exemption, because that could save your family $6 million in taxes. It's a big number, okay? The two most common mistakes, I would say, include, number one, failure to appraise the property. People say, well, you know, I talked to so-and-so, and they said I just needed a letter from a broker. I mean, come on. If this property is worth $1 million and you're avoiding $300,000 in capital gains taxes, you might want to think about spending the pennies it takes, right? When you look at this, spend the pennies it takes to get the real appraisal so that it's locked in. And these are day-to-death appraisals. Also, failure to file for portability. And unfortunately, I talk to colleagues, lawyers, and if you're a lawyer watching this, we get a lot of lawyers watching these, and you have a spouse pass away, you better have multiple disclosures, right? If that client of yours who is a surviving spouse does not go through the steps to file for portability, I would really encourage you to get a lot of signatures from the client at various stages saying, we advised you to get portability, you've declined. We've advised, you've declined. And if you're a client, if you're a person who's not a lawyer, and maybe you're a spouse or a surviving spouse, really look into this, this portability election, because you're picking up a free coupon that very well may go away. So Anita asks, if someone's spouse has already passed, is it too late to file a 709? It might be. And Anita, if that is your situation or somebody you know, you should call right away. I mean, you certainly can call us unless you're already represented by a lawyer, then talk to the person that's representing you, but get immediate legal help on that one. So if you're like, ooh, my spouse died 3 years ago, you still might be able to file for portability, maybe not. It depends on the situation. So something very important to be mindful of. Okay. So option one. So how do married people do estate plans, right? You can do wills that say, I leave everything to my spouse. You might have to go to probate. You might not. It depends on what the title is. And we covered that in other videos. Most of our clients do living trusts that leave everything. Most of our clients do living trusts, and many of those living trusts leave everything to a surviving spouse in what is called a survivor's trust. So you have, the Lee, Hal and Wanda Lee, they create a trust, Hal dies, all those assets flow into the Wanda Lee Survivor's Trust. And I've got an example here I'm going to show you. So this is a joint revocable trust. Now, I would say this is typical in community property states like California. In marital property states, we typically see separate revocable living trusts. Not always, but if clients come into the office and we sit down with them, or we meet them on Zoom and we start looking at their estate plan, if they have separate trusts, oftentimes those are from a separate property state and they've moved into a community property state. In California, they're typically joint trusts. You can have also a joint living trust that then becomes two trusts, or really pours over into two trusts. So the idea here is you have a trust that holds property while Hal and Wanda are living. Hal dies, and then this trust is split 50-50 into Hal's trust and then to Wanda's trust. Now, you may think that's over engineering, but you're going to see as we go through this, if it's a blended family, that might make sense. And so we'll talk about that. A blended family is where there's stepkids involved, right? Second marriage, that sort of a thing. So Hal and Wanda Lee have been married for 50 years, Hal and Wanda, and they have 3 children. When Hal dies, everything passes to their joint living trust and to Wanda in a survivor's trust. The way many survivor's trusts are written is Wanda has full power and authority to do whatever she wants with her inheritance from Hal. So Wanda remarries Ned and fails to update her trust. So this is part of that diagnostic that quiz we referenced earlier. If this is you, if someone's passed away and maybe you gotten remarried, you need to look at that quiz, because The fact of marriage changes the estate plan. So what do I mean by that? Well, Wanda has this living trust, and she says, well, Hal's passed away. I've got this living trust. I'm going to marry Ned, but I'm not going to change my trust because everything, I want it to go to my kids. Everything's there. It's already written. Nothing's changed, right? Well, the fact of marriage has the legal effect of altering the terms of a living trust. So this is something very important to understand. When you're looking at a living trust, and if it's your job to administer a trust, meaning if it's your job to carry out the terms of the trust, when someone has died, it is not enough to follow the terms of the trust. You have to look at the law, because the terms of the trust and the law working together determine who gets what. And in this case, because Wanda did not update her estate plan, Ned is what is considered a pretermitted, I hate that word, pretermitted. It's what they use in the probate code, means omitted spouse. So what the law does is they say, well, Wanda's got 3 kids. Well, sure, Wanda wanted to leave some of her separate property to Ned. And you know what? If she has more than 1 kid, it's going to be a third. That's what the law says. And Ned has enforceable rights as a pretermitted heir. So it would be better for Wanda to go back to the lawyer, right? And say, look, I married Ned, but I don't want him to get anything. I want it to go to my kids. She needs to update her estate plan to reflect that. So very, very important. Again, a marriage following death has an effect of altering your estate plan. So something very important to understand. And so here's kind of the graphic here, Hal and Wanda. There's a lot of stuff that happens when a person passes away, even on, I would say, a simple trust, right? This is kind of a simplified version of a trust. So Hal passes away, everything goes to Wanda, and then Ned gets everything. Let's say Wanda changes her estate plan and leaves Ned everything, right? Or at least he's going to get a third. So the whole point here is to show you that these trusts are fairly complicated. So again, there's another way to do this, right? Everything goes to Wanda. So let's say Hal's like, I'm worried about Ned. Maybe Hal and Wanda, they're married. And he's like, this Ned guy, I don't like him. So Hal and Wanda have been married for 50 years. And so Hal and Wanda write an estate plan that says when Hal dies, Hal's half of the property, Hal's half of the community property, which is Hal and Wanda's, so his half, plus his separate property, maybe an inheritance or a gift he received, and that passes to a trust for Wanda's benefit. So what that means is that's set aside for Wanda. Wanda is still the beneficiary. She still gets the benefits of that trust. But Hal says, I'm a little concerned what's going to happen after I pass away and what Wanda's going to do. Well, Wanda goes and marries Ned again and doesn't do any estate planning, right? So Wanda's half goes a third to Ned, 2/3 to the kids. Hal's half ends up going to the kids. So a little bit of a twist. So you can leave it to your surviving spouse with strings attached. And that's the point of that slide. And this is basically the same thing. Option 4, blended family, stepchildren. So I remember a TV show when I was growing up that had characters called Mike and Carol, and Mike had 3 sons, Greg, Peter, and Bobby, and Carol had 3 daughters, Marcia, Jan, and Cindy. And you probably have the song running in your head now. Mike and Carol, they set up a joint trust for their community assets, but they each brought assets to the marriage. And so what this means is, let's say Mike and Carol, they get married and they say, whatever we bring to the marriage, we want to keep separate. But whatever we acquire going forward, we want that to be community. Well, Mike and Carol can set up a community property trust, and so that their earnings maybe go into that trust. And then when Mike dies, Mike says he can leave all his community property to Carol, but then his separate property trust, so they end up with 3 trusts actually. Mike's separate property ends up going to his kids, and Carol ends up with the community property, right? And her separate property as well. Alternatively, Mike can leave the property to his half of the property to his kids in that separate trust. So the point of this slide is to let you know that if you do have a blended family, you may have to take a slightly more nuanced approach with your estate plan if you're really looking at community versus separate property. And there's some other reasons why we might have additional trusts in here that have to do with notice that we'll talk about in a few slides. So one really I don't want to say basic, because basic is it means different things to different people based on generation. But a spousal lifetime access trust is really a common tool for high net worth people. And this is going to be people typically who are over about $10 million, married people. So it's a strategy that's used while both spouses are living, and it's created and funded and takes on a life while both spouses are alive. So the idea here is that one spouse, Hal, gifts Wanda up to $12,920,000 in value without incurring a gift tax. And now Hal has used up his ability to leave $12,920,000 tax-free. It goes into a special trust. Wanda is the beneficiary. And so Wanda now is going to pay for dinner, and Wanda's going to pay for the movies and pay those expenses, right? Because that's a trust for her benefit. So sometimes you can put more into that. Now, what do I mean by that? Well, sometimes you can discount the value of a gift for lack of marketability and lack of control. So what this means is, if I sell you a pen that is worth $1 and I say, okay, this pen, you can't use it and you can't sell it, it's not worth $1, and the government says it's worth something less than $1. And when you do the math, it starts approaching about $20 million. So this works for real estate. It works for, can work for privately held companies, does not really work for publicly traded securities. But this is something, if you have real estate, if you have a privately held company, you can look at this as a strategy to really leverage the amount that you can leave tax-free, when both spouses are gone, because this really serves to reduce the overall death tax that's paid. You can compress values. You can also freeze the values. So when you make this gift of $12,920,000, if it grows to $50 million, right, it still passes death tax free to the kids. So it's a really good strategy for many, many clients. And this does oftentimes require a transmutation of property from community to separate property, which means you have to involve 2 more lawyers on a post-nuptial agreement. So there is a little bit of a little bit of care and feeding in the creation and the maintenance of the plan. But again, it's very commonly used strategy. So that's a spousal lifetime access trust. And that's something that we could certainly help you out if you're interested in it. So estate and income tax planning strategies for married couples. Married couples, there's a question: should you file separately or should you file jointly? We'll cover when and whether you should file separately or jointly. Are you in a higher income tax bracket? Sometimes you've heard of this thing, the marriage penalty. Capital gains and losses, you've got to look at that. That might drive whether you file separately or whether you file jointly. And then you're looking at mortgage interest and retirement contributions. And one thing on here is, if you own your own business and you're married and your spouse does not work and your spouse is not paid by your business, you might think about including your spouse on the payroll. Because if you include your spouse on the payroll, that spouse can make contributions to a retirement plan, right? A 401k or a Roth or whatever it is. And that's a great way of saving, and it's a great way of reducing income taxes. Now, estate and gift taxes, again, we talked about the SLAT, the Spousal Lifetime Access Trust. Burning one exemption is a good strategy. Something to understand is that you can leave $12,920,000 tax-free. And that's because there are 2 exemptions. There's an old one from 2011 and a newer one from 2017. And they're stacked on top of each other, meaning you've got your 2011 and your 2017 stacked on top. It's like a cake with frosting. The 2017 exemption is the Trump exemption. That's going away in 2026. The frosting is being taken off the cake. When you make a gift, you make it from the bottom up. Okay, you don't make a gift of your 2017 exemption. You make it from the 2011 exemption first. So if each spouse has 12 million bucks, it makes sense, instead of each spouse gifting 6 million, leaving you no exemption for either spouse, it makes sense for one spouse to give the 12 million, right? And the other spouse then after 2026 has a $6 or $7 million exemption. So we cover that in a lot of other webinars, but a lot of other videos on YouTube. I would encourage you to take a look at that. And that's just the sort of the nuance. And this is why you really need to go to somebody who knows what they're doing, because if you don't, a lot of people don't know this. A lot of lawyers have no idea. If you're a lawyer watching this, you're like, well, I didn't know that. But you make your gift from the oldest exemption first, not the newest. So very, very important. So there is a little bit of what's called the innocent spouse trap. And this is really if your spouse is up to no good. And I would say, if your spouse is up to no good, first of all, don't go on a reality show. Don't go on the Real Housewives or wherever, because we've all seen that lately a lot, right? And also consider filing separately, because spouses are jointly and severally liable, even if one is the innocent spouse. So if one spouse is up to no good and the other spouse has no idea and signs a joint return, that innocent spouse can be liable for all the bad stuff that the spouse is up to no good is doing. But married filing separately does have its disadvantages. Your tax rates are typically higher than it would be on a joint return when you look at both of them. It does limit your IRA contributions and limits the tax credits you can claim, and your capital loss deductions cut in half. That being said, there are some reasons why you would want to file separately, right? If your house has if your spouse has a previous tax liability, that's a biggie. So if you marry somebody, right, you might marry somebody and not know they have a big previous tax liability. Now, I'm not sure people talk about that when they're dating. The last time I dated was when I was 23, and I didn't think I'd filed much of a return. But if you're older, that's something you certainly would want to be mindful of. If you file jointly, your refund applies on the balance owed. So if one spouse owes and you don't, and you're expecting a refund and you file jointly, it's going to go it's going to pay down. You're not going to put that money in your pocket, right? And if one spouse is on an income-based debt repayment plan for taxes, like, hey, I don't make enough, can I do a payment plan for my taxes? And filing jointly might make those too high. So this is like if someone's gotten into tax trouble in the past, or if you're in the process of divorcing, right? That would be a reason to file separately and not file jointly. The married filing jointly can interfere with some miscellaneous deductions and medical expenses. So what some people do is and not everyone does this, but some people do run the numbers married filing jointly and then married filing separately and comparing the two and see which one is a better benefit. But if you got some tax debt that you're dealing with, if your spouse is up to no good, this is something to really, really pay attention to, because you can get left holding the bag on that. Well, that concludes our content. We do have offices in Northern and Southern California, sort of Bay Area capital region, as well as Pasadena and Westlake Village. And if you saw this and you went, wow, I need help, right? Or if you're thinking, I need to talk to somebody, go ahead and give us a call. You can give us a call, but here's what you should expect when you do make a call. You're not going to speak with the lawyer, right? It's not the FBI where they answer and it's an FBI agent. You will be connected with the client specialist, not one of our lawyers. Do let us know if you want to update or create an estate plan. Also, let us know if somebody's died. That's kind of the fork in the road. If someone's passed or become incapacitated, that's a little bit of the fork in the road into which department it goes into. In our firm, we have a lot of lawyers who focus on estate planning and a lot of lawyers who focus on trust administration. And so there's a little bit of a divergence there. And tell us your estate and tax planning goals. I want to save income tax. I want to, save on death tax, whatever your goals are. And then don't ask for pricing. Only attorneys can quote fees, and don't ask for legal advice, because only attorneys can give legal advice. And the goal of the call is to set an appointment with an attorney in the firm. And if you're watching this on YouTube, go ahead and subscribe to our channel, click the little bell, and that will alert you when we post new content, which we do quite a bit. And our next video or webinar is the proposed tax laws for long-term care policies and how to repurpose your life insurance to help. So this is really important. California right now is proposing mandatory long-term care insurance. They're talking about it. Washington has done it. It very well may be on its way, and you don't want to get stuck with a crummy policy, which is oftentimes what happens when the state mandates something. It's, they're checking a box, but really, really pay attention to this, because long-term care for a lot of people is super important. And many people have a long-term care policy that may suit their needs or not. And if you have old life insurance, you can typically repurpose that for long-term care insurance.